Think we're live. Oh, I don't know, I don't know why. Oh, I don't know why. Yeah, we're good. We're up and running. How we doing? How we doing? As always, this is not legal advice. We do not offer legal advice. If you are looking for legal advice, reach out to a licensed attorney in your area. This is for educational, entertainment purposes only. So starting off, here's the thing. Here's how I operate. How I sometimes operate. Try not to, but I try to be very conscious. I just want to apologize if I went back and watched part 5. A little bit towards the end, I started speeding through reading. So if you guys notice I'm starting to do that, please feel free in the comment section. Hey, you're reading a little fast there, because I want this to be a thorough read through, and I think we covered a good amount of details pretty well. But again, I want this to be as smooth and as efficient as we can possibly make it. This is for everyone's benefit, but I want this to be for you guys, to help you guys. So if it's not to your liking, please say so in the comment section. Please say so. Shoot me a message. Like, share, subscribe, etc., etc. Go follow us on Instagram if you have not. Govern.yourself.accordingly. We share some of the clips over there, but we're thinking about getting some other content shared over there as well, as we start to get a foundation for what we're looking to accomplish. Um, we obviously have a few documents that we are looking to cover here in the near future. But if there are any other documents that you guys think that we should be covering, or any concepts even, or case law, or anything, please feel free to shoot that to us, because yeah, the more the merrier. Never stop learning. When you stop learning, you forget what you already know. So with that being said, we're gonna get into commerce and operating in business today. Now this is the good stuff. I think most of what we've covered so far is pretty straightforward for those who, even in the smallest sense, understand what trusts are and what they can do. But now we're gonna get into a little bit more detail. If there's any questions or any ambiguity on any of the previous parts, please do yourself a favor, do ourselves a favor, and write in the comment section. This is going to help clarify things for yourself and for other people that may have the same questions. So, with that being said, let's go ahead and get into it. So, understanding commerce. What time do we got? Lovely. Okay. All right. Here is where we begin to address the express trust in action. As shown above, the trust may engage in all manner of trade and commerce. The words trade and commerce in the footnotes 125 here are often used interchangeably, but strictly speaking, commerce relates to intercourse or dealings with foreign nations, states, or political communities, while trade denotes business, intercourse, or mutual traffic within the limits of a state or nation, or the buying, selling, and exchanging of articles between members of the same community. Black's Law Dictionary, 4th edition. That's the gold edition right there. If you can find that, buy it and keep it and pass it down to generation to generation, because it's good. Understand the difference here. When we're talking about commerce, it's talking about from nation to nation, if that makes sense. Whereas when we're talking about trade, we're talking about in between a nation, if that makes sense. Now, why is it used interchangeably? Well, it just came to my mind is because a lot of people don't know this. The United States of America is a collection of nations. A lot of people don't know that. It is a collection of nations. So then when they were all commercialized, they were still a collection of nations, not under the republic, but underneath a democracy under the commercial code, if that makes sense. That's why each state has a constitution. If that weren't the case, then they wouldn't need a constitution. They're all individual nations. So that's why that word is used interchangeably. That's part of the reason why. That's not the full reason, but I want to continue on without going too far into it. So just understand trade, and when we're talking about United States of America, United States and the United States of America, which is the Republic, we're talking about, when we talk about trade and commerce, we're talking about basically the same exact thing. As shown above, the trust may engage in all manner of trade and commerce, but before taking the step of doing so, the reader would greatly benefit the trust by understanding the nature of commerce in 21st century America. And for my brief explanation of the subtle intricacies involved, I will rely upon two works by Liebobst et al. 26. See footnotes 1499. Yeah. And for my brief explanation, I will not go into a detailed explanation of the Constitution or the history of commerce for want of space, but I would suggest that the reader read the works relied upon herein. I would highly, highly recommend you have a base understanding of commerce. Because as I was saying the other day, like, obviously, like, you gotta, here's what I'll say. Because there's people that for some reason think that, like, again, like, I'm gonna fight the system, and I'm not gonna operate in commerce. Like, I'm sorry, but you're fooling yourself when you're coming to that. Unless you have your own military, your own currency, you're like truly, truly sovereign, you have to, in order to sustain yourself. And having that understanding of how commerce works, is going to be to your benefit. Without going too far into it, it's extremely important. There's people that are pissed off at the system. Well, I'm sorry, the system is the system. It's your frame of mind that is keeping you from operating more efficiently in the system. It's really important. I really want to beat that home because, yeah, I mean, it's just like unless you have $100 million at lotto just dropped on your head, you have to rely upon it to a certain degree. You know, it's about being wise. How do I say this? No, I'll come back to it because I'm sure it'll come back up. I'm gonna try to stay on a good pace here. But at the end of the day, you need to study. You should go into some UCC and study it. You should go and study how commerce has evolved from the 1900s up until now. You should go study some case law on commerce. You know, you don't have to. You don't have to memorize the UCC from front to back. There ain't a soul here on this planet that has done that. Maybe outside a few judges. Because it is very extensive and it can be very complicated. But I know that once you begin to understand the terminology of the UCC and how that operates, you can understand anything. Like, it's like the floodgates completely open. So, with that said, in your spare time, do yourself a favor. Look into the history of commerce and how things are truly operating within the federal jurisdiction. But let's keep going. When the trustee is engaging in trade or commerce in behalf of the trust, acting under the general law, the trust is within the jurisdiction over which the literal and absolute protections of the Bill of Rights extend, and he has no direct contact with the federal government. So when we talk about engaging in trade or commerce on behalf of the trust, acting under the general common law, the trust is within the jurisdiction over which the literal and absolute. We're talking about again, like we've been talking about the common law jurisdiction, not the congressional legislative jurisdiction like we talked about last time. Under right of contract law, protected by the federal Constitution, the trustee may enter into the 14th Amendment jurisdiction via contact, i.e., by willfully availing the trust of benefits like the quasi-corporate privilege franchise of limited liability for the discharge of debts using Federal Reserve notes, dollar bills, pursuant to the economic system established under House Joint Resolution 192. Let's look at it. This is a big one. This is fundamental, and I need to broaden my understanding of it. I have a pretty solid understanding of it, but I want to understand it from front to back. So, House Joint Resolution was tacitly repealed on October 27, 1977, as codified at 31 U.S.C. Section 5118, Section A, Section 1, and Section D, Section 2. And no gold clauses have since been upheld as legally enforceable again. See Fay Corp versus Frederick and Nelson, Seattle, Incorporated. It successfully put in place a system which survived the repeal, and thus today most participants make no noticeable use of the now legally enforceable gold clause. Therefore, all discussion relating to HJR 192 remains valid in the sense that nothing has changed materially since its repeal 30 years ago. So essentially, long story short, House Joint Resolution 192 completely took us off the gold standard. And by doing that, it created the system for the discharge of debts using Federal Reserve notes. Basically, you're paying everything you buy today, you're using debt to pay for. And a lot of people don't realize that. And what's important to distinguish here is we can use gold clauses because HJR 192 was repealed. But even though it was repealed, the system of Federal Reserve notes was already so well established. People were just like, whatever. This is the part of this. Like when I read this, it's like I don't know when. Obviously, like we're going from dollars to digital currency and whatnot, but gold at some point is going to be somewhat significant again. I don't know how significant or what, but it's going to be significant in terms of how we either support a currency or support our transactions in commerce. That's just my opinion. I can't base that off of anything outside of this. But the reason why this was repealed is because this is unconstitutional. House Joint Resolution 192 is unconstitutional. Why? Well, if you go back to the part where we talked about the land, the gold being part of the land, being portable land and tied to the law, you can't get rid of something that is ultimately like one of the big distinguishing factors of how our system works, our constitutional common law system works. So that's why it was repealed. Benefits by willfully failing the trust of like the quasi. Let's look at quasi because I want you guys to get an understanding of what that means. Basically means like kind of, sort of, but not really. But let's get a full look at it. Quasi contract. A determination by a court about the obligation of one party to another. No actual contract exists, but the agreement is similar to a contract. It is based on the conduct of the parties, their relationship, and that one party may become unjustly richer without the court's intervention. So, as you see here, there is no actual contract. Willfully availing the trust of benefits means, okay, there's no direct contract between me and the trust and the United States federal government, but through my actions of using Federal Reserve notes, there is a slight contract there. And people will argue that it it only goes so far. It only goes so far. So, but I just wanted to point that out what a quasi contract is, just in case you were like, well, what's that mean? So, under this jurisdiction, the federal government, Congress, has full and direct contact with the trust as they see fit for the benefit of public policy regulations, known as what? Codes and statutes of this jurisdiction. What we've been talking about this entire time. 128. The law of the money in your choice. Page 3. Don't got time right now. This makes the federal government a third-party intervener in the affairs of the trust by operation of law. Basically, a constructive trust, a implied trust, or implied party, if you will, like we talked about in the earlier parts. The 129, the federal government's power of regulation in this manner is fully constitutional, deriving its authority from Article 1, Section 8, Clause 1 and 8, being one of the general legislative powers. The relationship between Congress and the 14th Amendment citizen is controlled under Article 4, Section 3, Clause 2, because there is no federal or state charter issued to regulate the relationship. So you're probably sitting there like, what the heck, dude? Like, you just told us, like, trust this, trust that, and all of a sudden now we can't use dollar bills. They're not, how do I say this? I don't want to say they're not or they aren't, because if you are wanting to operate through trust and you're wanting to protect your assets, you don't just have one trust. That makes no sense. You have one trust that you operate in the public with. This is not legal advice. This is for entertainment, educational purposes only. You have one trust you operate in the public with. And then you have another trust that you do whatever with that holds land that has no ties to the interstate banking really coalition that we're going to talk about here in a little bit. You have one trust that is tied to this. You have a charitable trust. Then you have a ministry. Then you have like literally, you can have so many different things set up that you don't have to you don't have to use dollar bills for every single trust. You don't. You can transfer the property in and out. And that's that, you know? Obviously, when we're talking about irrevocable common law, private express trust, etc., Massachusetts business trust, etc., we can't take the property, put it in, and return it back to the grantor, which it came, but we can transfer that party to another trust for the benefit of the beneficiary, if that makes sense. And I just wanted to make that distinction because everyone probably reads this like, oh no, I'm wasting my time. I'm screwed. No, you're not screwed. You're not. It's just learning how to operate so much in the private that your affairs are like so like handled. Like they can't. What are they gonna do? You know what I mean? Wise as serpents, harmless as doves. Right. Continuing. Did I skip a big part? No. This makes the federal insurance come along because the trust, as with 14th Amendment citizens, is allowed to get away with not truly fulfilling its commercial contracts as required under the common law of contracts. I will show how this can be avoided in a later section. And I don't remember reading this part before, but I'm looking forward to this. Let's keep going. The resulting nexus or confederacy developed under House Joint Resolution 192 is an affiliation known better as an association. 130. An association is defined as an unincorporated society, a body of persons united and acting together without a charter, but upon the methods and forms used by incorporated bodies for the prosecution of some common enterprise. So let's look up association, because you can form your own association. Or sorry, I didn't want to look up association. I wanted to look up charter, because you can form your own. You can form your own association. The act of legislature that creates a corporation and sets forth its franchise that defines the organization of a corporation. So here we have it. We're not asking for their permission. I'm sorry. Where did it go? We're not asking for their permission. We're not asking. Does that make sense? Um, I keep going too far ahead. Sorry, I always lose my spot when I go to the footnotes. Um, Association. And the common enterprise. Okay, let me just read. And the common enterprise of this unincorporated society is to offer all Americans a so called privilege in the form of what is better known as a quasi contract to participate in commerce without payment of debts for social security purposes. I'll read that again. And the common enterprise of this unincorporated society is to offer all Americans a so called privilege in the form of what is better known as a quasi contract, a contract that is not written, but is implied through my acceptance and action and retrieval, whatever you want to call it there. Sorry, bad grammar. Of that benefit to participate in commerce without payment of debts for Social Security purposes. They're telling you right now. That's why do you think our national debt is $50 trillion? You can't pay for debt with debt. Social Security purposes. Because we're sureties for that debt. Don't believe me? Look up the case law. Moreover, this unincorporated society is outside the literal common law principle that demands the payments of debts, as stated in Article 1, Section 10, but is allowed, upheld, and protected by Article 1, Section 10 that upholds the obligation of contracts. This amounts to a federated, unincorporated society by operation of law, which is contractually protected by the Constitution in the same way the express trust and its trustees are. And the trust or trustee reserves the right to domicile themselves in the Union under Article 4, Section 3, Clause 1, and thus to contract under Article 1, Section 10, despite the fact that they cannot pay their debts. In other words, Congress cannot compel the trust or the trustee to participate in a federal, interstate, unincorporated banking association under Article 4, Section 3, Clause 2, and House Joint Resolution 192 for the non-payment of debts. The choice of law is up to each person still. There's a lot there. So basically, like, long story short, Social Security Administration taking away all the lawful money, creating legal tender through the Negotiable Instrument Acts in 1933. Sorry, the Negotiable Instrument Act in 1933, and the creation of the Social Security Administration, and um, obviously us going bankrupt, and I can't think of the words right now, but long story short, um, they created a trust through that, which is it's 100% constitutional. But you have to know how to essentially weave yourself in and away from that, if that makes sense. Let me go back up, because there's some details I want to point out. This unincorporated society is outside the literal common law principle that demands the payment of debts as stated in Article 1, Section 10, but is allowed, upheld, and protected by Article 1, Section 10 that upholds the obligation of contracts, because it's a trust that they did. They created a trust. This amounts to a federated, unincorporated society by operation of law, which is essentially an implied trust and constructive trust, protected by the Constitution the same way that express trust and its trustees are. And you can do this yourself. Obviously not for these heinous purposes, but you can create an unincorporated society, a PMA, if that makes sense. Fully protected. Now, the way that you have to operate it out of it is a little bit different, but you can do that yourself. They actually gave you the roadmap a little bit. So let's continue. I'm going to come back to this at the end. Corporations are artificial creations of the state, like we've been saying, or federal government under physical charter, franchise. Remember, charter is the act of legislator that creates a corporation. issued via state or federal civil law for commercial regulation under Article 1, Section 8, Clauses 1 and 3. They are not under the literal common law because of the charter franchise. Any legal action against the corporation is legally called an in rem action, just like we talked about in rem jurisdiction before, because it is against the thing or property, also called res, of the corporation under charter. The courts have automatic subject matter jurisdiction because the physical charter is the subject matter. It's over. You're in that jurisdiction, whether you like it or not. Basically, you can't escape. Under the letter of the constitutional law, there is no commercial regulation. House Joint Resolution 192, along with 15 U.S.C., brought in a third party for commercial regulation for the Social Security public policy. Remember, equity compels performance. This is a maxim of law. The law views unincorporated associations as a danger to the substance of the common law because of their debt credit system. This is because there is no counterbalance to the demands the association puts on the substance of the earth. Thus, the reason for all the federal and state regulatory agencies. In other words, there is a presumption, meaning something they're making you think is a fact when it's really not. Necessarily it could be, but it has to be completely rebutted or proven. By implication, I paraphrased the heck out of that. I don't like leaving details out. Sorry. An assumption that is created by a law that exists and forces the court to make a certain conclusion. We have another one. Presumption of fact. The logical conclusion that is based on unproved facts that are related to the matter at hand. So, kind of, sort of, a better definition than what I told you guys. In other words, there is a presumption by implication in the civil law that a charter, a metaphysical, abstract, unreal type, exists because the persons are availing themselves, volunteering of the privileges pertaining to House Joint Resolution 192. Therefore, these persons come under a quasi-in rem jurisdiction of the civil law in order to regulate, control, including compel, those that are outside the literal common law principles. 134. Okay. Basically, if you're availing yourself to something, that means there is something that is in control, whether it is a contract, whether it is an entity, whether it's anything. You know, just think of it as a base principle. If any of these concepts ever get confusing or overwhelming, think of like our creator, because all of this stuff stems from our creator. It stems from spiritual law, natural law. We decided to come on the earth and have dominion over it and till the land and follow instructions. Why? Because the creator told us to. Even if we didn't know our creator, we know that we were created by something. And we do things because we were created by that something. It gave us a purpose or the desire to seek out that purpose within our own lives. The same thing applies here, but obviously in a negative connotation, because now they're pulling you into that jurisdiction. Just like you've been pulled into that jurisdiction by using those Federal Reserve notes, you are underneath the jurisdiction of the Father at all times. You know, and that's why it's to your benefit to do good and to follow His instructions. But yeah, I wanted to explain that because that is important. If you're getting confused about that, the many participants under this system, especially the 14th Amendment citizens from each state, together form an unincorporated federation of state associations operating under interstate commerce as addressed in Article 4, Section 3, Clause 2, and reinforced in the landmark Erie Railroad Company versus Tompkins decision. It's probably the biggest decision in the entire United States. If not, probably Hale versus Hinkle is right there next to it. This is the basis for the federal and state government's compulsion of persons to its private international law, i.e., the spirit, not the letter, of the common law, mixed with public Roman civil law under Law of Nations per Article 1, Section 8, Clause 3 and 10, and Article 4, Clause 2. Sorry, Article 6, Clause 2, my bad. Nowadays commonly known as codes and statutes, to regulate everything as a matter of commerce. So do you remember on the last part I was telling you, not all codes and statutes are necessarily bad. And this is why. The government's compulsion of persons to its private international law, the spirit of the common law, mixed with their public statutes and codes, Roman civil law. This is where the trickery is at. They want you to think, oh, well, the statutes and codes, they're pretty. Some of them are pretty good on their face, but then some of them start to stray further and further away from the intent of the Constitution for each state and for the United States of America Republic, if that makes sense. Regulate everything as a matter of commerce. 136. This can be better understood from Propeller Genesee Chief versus Fitzhugh, wherein the court said that within the letter of the Constitution, the law contains no regulations of commerce. It merely confers a new jurisdiction on the district courts, and his is the only object and purpose. It is evident that Congress, in passing the law, did not intend to exercise their power to regulate commerce. The statutes do no more than grant jurisdiction of a particular class of cases. Again, it's all talking about jurisdiction. And when you understand jurisdiction, everything, public and private jurisdiction, which they intermingle. They have a lot to do with each other, but those are the two things that you got to understand in order to be able to okay, this makes perfect sense. Now, the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land, the law of the land, the common law, maritime admiralty, law of the sea, public, land, private. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason would justify the same exercise of power on land. See Verlinden versus Bank of Nigeria. Roman civil law is also why the IRS continually refers to income taxes as voluntary, although to the ignorant, it appears to be the exact opposite. It is a voluntary level 5 gift. And a lot of people don't realize that either. So, this is telling you right here. This is case law. Again, remember, mandatory authority. Let's look it up. Telling you, we got two jurisdictions going on here. Which one are you in? Sorry, type it with one finger. No, don't do that to me. How do you guys do this? Man. Sorry. Authority. Mandatory authority. This is from Cornell. Mandatory authority, unlike persuasive authority, describes legal authority that is binding and must be followed. All mandatory authority are primary sources of law. Mandatory authority consists of constitutions, legislations, and judicial decisions, aka appeals and Supreme Court rulings. Constitutions derive their authority from the people. So constitutions bind only those who have agreed to be bound. That's why the Constitution of the United States is mandatory authority in every state and every court in the United States. An individual state's constitution is mandatory authority only within that state's jurisdiction. Notice how they keep bringing up that word jurisdiction. In this situation, even though a state constitution is a primary source of law, it is not automatically mandatory authority. For judicial decisions, vertical stare decisis dictates that judicial decisions by higher courts are mandatory authority for lower courts. Horizontal stare decisis, on the other hand, is generally not binding, or it is persuasive. The body of binding judicial decisions is specific to a jurisdiction. Therefore, judicial decisions by court of one jurisdiction are not mandatory for courts of another, but when it's the Supreme Court, it's binding on everyone. So just remember that. Okay. Without getting into the history of religion and speaking purely from an analytical perspective, the Roman civil law as a base model for commerce regulation was developed out of necessity of the church to avoid political scrutiny for its handling of ever increasing amounts of precious metals. It had become a storehouse for the money and property the people were persuaded to give in exchange for limited liability. Go directly to heaven instead of what? I mean, that's literally, it's tithe as an offering today, but yeah, as the people, as the people became more educated, forgot about that one, and saw what was really behind the power of religion in generating wealth, the Roman Catholic Church fell under greater and greater criticism. This led to the development of a banking system to handle, and control church wealth and take the critical focus away from the church. The house that no one lives in, the Republic. It's really good. The title alone tells you the Republic is the house that no one lives in. The bank learned from the church about limited liability. If you could get people to borrow money beyond their ability to pay it back, you could get them to keep performing, paying interest in one form or another, on a debt liability without ever demanding it, the principal back, the original amount of payment, thereby loaning out that same credit to more than one individual or company. This meant that the bank was limiting the liability of the borrower, so he was not fully responsible for the debt as long as he continued to perform to paying the interest. This way, real money, gold, became credit, paper money, by loaning to more than one person. Being involved in this sort of commerce was called private commerce, private banking. With the church's control over wealth, this private commerce became standard practice in world trade upon the sea. Private international, or admiralty maritime, became known as Roman civil law as it began to figure heavily in the politics of every city and country it touched through international commerce. 138. You know what? I'm going to stop here in a second to make this short, and I'm going to take a 5-minute break after this last paragraph, and I'm going to do doing business after this because I'm feeling good today. We're going to do that. By operation of this body of law, particularly its in rem being things, element, all persons subject to its jurisdiction are not necessarily regarded as fictional vessels per se, but are more so as objects of the state, discussed earlier, see footnote 24. These objects, like vessels in traditional admiralty practice, are vested with a distinct quasi-corporate, meaning might not have a direct agreement written to make it a corporation, but it is corporate in nature, juridical personality, but unlike vessels, are capable of suing and being sued in personam. 139. Yeah. Oh, we got a link here too. Might not work though. 14th Amendment citizens of the United States, whether state or federal, chartered corporations or metaphysical chartered, corporate colored public persons, therefore, are akin to public vessels of the United States within the broad meaning of the Public Vessels Act and are regulated accordingly. The United States, as with the Roman Church, is considered in international law as a ship of the state. The express trust, then, is akin to a private vessel of the United States of America, navigating through the often hostile waters called international commerce, which is international commerce via the United States treaties. So basically, your straw man. That's what it's talking about. Your social, your that you're doing business as. You're always doing business. You don't realize it, but you are. You're always doing business. You're always operating in commerce to a certain degree, unless you're in the private trading gold and silver. Even when you're using the Federal Reserve notes, you're operating commerce. You are. because those are debt instruments. They don't. That's a promissory note. It's a promise to pay. That's why it's called a Federal Reserve note. It's a promissory note. Let's look at a promissory note, and then we'll shut this down and take a 5 or 10 minute break, and then we'll get to part 2 because we feel good today. We want to talk about business. I like business. I like it. I don't know if you guys do, but I do. Promissory note. We could have just looked it up. Promissory note. A written promise to pay a debt by a specific date. It can be turned to cash by transferring it to another party. Let's get a better definition. UCC 1 dash, or is it UCC 2? I think it's UCC 2 201, but we're just going to type in promissory note. Come on, don't do this to me. UCC promissory note definition. Corner. I think I just butchered that. I'm not looking up right now. Negotiable instrument. Okay, this is what I was looking for. 3104. Okay. Except as provided in subsections C and D, negotiable instrument means an unconditional promise or order to pay a fixed amount of money. A written promise to pay a debt. So they're telling you it's a debt note. Negotiable instruments are debt notes. We're only dealing with debt notes. With or without interest or other charges described in the promise or order if it, 1, is payable to the bearer or to the order at the time it is issued or first comes into possession of a holder, is payable on demand or at a definite time, and does not state any other undertaking or instruction, etc., etc. Instrument means a negotiable instrument. An order that meets all the requirements of subsection A, etc., etc. Check. A promise or order other than a check is not an instrument if at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed to the effect, etc., etc. An instrument is a note if it is a promise and is a draft. Check means a draft. Man, like this stuff, like some of these definitions, they run so deep. But yeah, that's pretty much that. We're gonna shut it down there. We're gonna take about a 10-minute break, and then we're gonna get up and popping with part 2. I hope this was informational. I hope this was beneficial for your informational purposes. Again, this is not legal advice. It's for entertainment and educational purposes only. I'm gonna shut this down, and